Yanes versus City of New York. Yanes, I'm sorry. I said Yanes.
Good afternoon. May it please the court, Mackenzie Fillo for the Department of Education. This court should set aside the verdict because it is excessive when compared to the awards approved in similar severe burn cases. Appellate Division precedent sets a range of reasonable compensation for severe burns from $3.6 to $16 million. And the only question here is where exactly in that range this case falls. The facts show...
So, counsel, you don't see this case as unique?
It is sadly not unique.
It is not unique. There's prior cases involving a 16-year-old burnt in a high school experiment where 51% of his body is burned.
Actually, only 31%.
31% and the other 20% skin grafts, right? So he loses 51% of his body surface. He has debridements in the morning. He has procedures in the afternoon to put the grafts on.
Mm-hmm.
He has, I mean, I could go through the litany that was outlined in the 38-page written by the trial judge,
Mm-hmm.
affirming the jury award.
It is undeniably tragic, but sadly, these are the sufferings of every single person who suffers a severe burn.
In this magnitude, at this age, with a 54-year-old, with a 54-year life expectancy.
Yes, in fact, we have the case of Lee.
Did Lee have to undergo 120 procedures?
I'm not sure exactly how many procedures he had, but Yanes had 5 surgeries, and Lee had 7 at the time of trial and still needed 5 more. If you look at the facts of Lee,
Yanes had more than 2,000 staples put into him as a result of the surgeries, had skin removed from his scalp, and had to wear a compression suit. Let's see.
Lee had all of those.
What else did he have, counsel?
Lee, just like Yanes, Lee had to wear compression garments for a year at least. They both wore a neck brace. Lee also required chest plates. Yanes lost his ears. Lee lost his ears plus 2 fingers, a nipple, and his belly button.
Yanes was degloved. Are we going to go one-on-one on this?
Yeah, counsel, I don't think this is going
Really?
to work. I really don't. And I find it to be a little bit disconcerting that you would actually make the argument that the horrific injuries that this 16-year-old suffered are in any way comparable to those sustained by Lee. So I think you should just get to your point in terms of what you believe what you believe we should do.
Our position is that the court should set aside the verdict unless the plaintiff agrees to a serious reduction in line with what...
What was your position at trial, by the way, in terms of what the damages should be?
I'm not sure if we presented a specific number. I don't know if that...
Did you present any evidence to rebut the evidence that was presented by plaintiff on damages?
I don't think we did, but the point here is not that he didn't suffer. That's, to be clear, everyone agrees that Yanes suffered terribly. The question is whether $59 million, which is dramatically more than any pain and suffering award that this court has ever affirmed, is appropriate in this case, where there are people who have suffered much more extensive burns who got way less. The point of 5501 is that this court needs to take a step back and look at this case compared to other severe burn cases. The jury didn't have that opportunity, and it's not the jury's role, in fact, to do that. The legislature directed this court to stop runaway jury verdicts. It thought the legislature considered putting a cap, and instead it chose this more flexible...
But in Reed, the first department said in 2003 that personal injury awards, especially those for pain and suffering, are subjective opinions, which are formulated without the availability or guidance of precise mathematical quantification. So here the jury sees and listens and observes.
Sure.
The plaintiff and everyone who testifies on both sides, on the behalf of both sides. And here you have a judge who says, I'm not setting aside this verdict.
Yes, the judge actually made a serious legal error. He seemed to think that he had no power to set aside the verdict. That is plainly wrong.
I think you're mischaracterizing the opinion.
He said, I believe he said something like the role of the jury is to decide the damages. It would be unconstitutional for me to set them aside. That is incorrect. But even if he decided not to do it, the point is that the legislature directed this court to set aside these enormous verdicts to ensure that similar plaintiffs receive similar awards. And that is not happening here. What happened is that Lee got a $5 million award.
But Lee was not a jury case, was it? Wasn't it a court of claims case?
It was, but this court...
So you didn't have a jury evaluating the evidence in that case and determining that $5 million was actually reasonable compensation for someone with those injuries. That was not a jury that did it.
The same standard applies in cases that go before a bench trial as in a jury trial. And when you compare this case to Pete, its excessiveness is even more obvious. Pete was burned on 50% of his body, and his damages were dwarfed by the enormous award here. The legislature directed this court.
How old was Pete at the time of the injury?
Pete was
37,
37, but even if you look out, if you do the math and see, the jury says how long they expect him to live. And if you look at it per year, for example, for future damages, Pete's award is $187,000 per year.
So this young man is expected to live another 54 years with these horrifying injuries, right?
Sure, but the 20-age difference, isn't there? A 20-year difference between Pete and Yanes?
Yes, but if you look at the per year award, that's what I'm saying actually. So Pete's future award was for 32 years. It was $187,000 per year. Yanes's is for 54. It's $547,000.
At the same level as the pain and suffering of a 16-year-old?
I have the record here with the photographs of Pete. It's worth looking at these photographs to see what Pete went through and compare them to what Yanes went through here. This is what the job of the court is to compare the two cases and see where does Yanes's case fall on the range of this court's past precedent. Pete suffered enormously. His burns were on 50% of his body. He lost body parts just as Yanes did. Even though he was older, the court can do the math, and it's very clear that Pete's award is tiny compared to Yanes's. And the point of this court is to make sure that plaintiffs who suffer similar injuries receive similar awards. And that's why this court needs to set aside the verdict or if the plaintiff won't agree to reduce it. I'll save my time. Thank you.
May it please the court, good afternoon. My name is Ben Rubinowitz. I represent Alonzo Yanes and his family.
So this award is substantially larger than any other award. And again, if you put it in the context of Pete as well as with it's far, far more.
If I may, Judge Weber, thank you for the question. There is one major distinction with this case than any other case. Alonzo Yanes lost his entire face and ears. In fact, every square inch of his face and head was either burned off or surgically removed. Not one of the other cases, whether it's Weigel, Susan Weigel didn't have an injury to her face. Christopher Pete, had no injury to his face, and I agree with counsel. I would like you to see the photos. I actually have them here so that you can take a look at them if you'd like to compare them. I have photos of Alonzo Yanes, 10 of them that are representative, because the scanning doesn't accurately portray what Judge Tisch saw in the courtroom. And I'd ask you to please take a look at them. I could refer you directly to the record. Not one other case, whether it's Lee, whether it's Niesel, none of those cases did the plaintiff lose his face. This is a 16-year-old child. Not only did he lose his face, but what wasn't mentioned by counsel is that he suffered methanol toxicity to his kidneys, to his lungs, to his trachea, to his larynx. He actually had degloving injuries to both hands where all of the skin was removed. He had 2 1,000 staples and more, trying to hold the cadaver skin, the dead skin that was affixed to his face. And then he suffered something that none of the others had, which was methicillin-resistant Staph aureus, flesh-eating bacteria that destroyed the cadaver grafts, and it had to be removed, surgically taken away. These are operative procedures.
Well, counsel made reference to the fact, I think that Pete, I forget, there were more surgeries in that case than there was in Yanis's case.
So I thank you for that question as well. Nothing could be further from the truth. Dr. Yurt, who testified, and the city chose not to even bring in one witness, as Your Honor so carefully pointed out, Judge Mendez, there were over 120 surgeries. We're not talking about simple debridements like a Band-Aid. They actually removed his ears in pieces. They actually scraped away his entire face, his entire head. If you take a look at the record specifically, and I go to the appendix 2513, 2519, and 2522, you'll see every square inch of his face. There is no case like this. This case is a complete and total outlier. No case have I ever stood before you, and I've argued, for example, in Aguilar, where there have been 9 surgeries or 10 surgeries. We're talking about 120 surgeries. Very much, Your Honor, you decided the 91st Street crane collapse, and in that case, you actually spoke about how different it was than the others, and you spoke to us and provided guidance for us to teach with the other lawyers, and I've done that. And so have you, Judge Mendez, when you actually cited it being the trial court judge in that case, how different it was, and why it requires a variance. So what I did was I did an apples-to-apples comparison. If you take a look at the Susan Weigel case, which the city improperly cited as being a 2013 case, it's a 2003 case, and it's a case where the verdict was in 2001. 17% of her body was burned. She required 2 skin grafts, and they awarded $8 million. If you do the extrapolation, and you show the extrapolation for both the percentage of skin burned and the number of years, the verdict would have come out to, if we actually add for Alonzo Yanes, it would be $40,909,000. That's an exact number, taking into account inflation, taking into account, if you use the U.S. Bureau of Labor and Statistics calculator for inflation.
So, counsel, you're arguing that the hard number should not be used if one is to look at this in a formulaic manner, but rather that the number should be increased or decreased according to what?
I'm saying this. The reason Weigel, even if it's $40 million on an apples-to-apples comparison, she didn't lose his face. Alonzo Yanes can't walk down the street, and he'll never be able to walk down the street for 54 more years, where we know the injuries will be 2 to 3 times worse, because that's what Dr. Yurt, not a courtroom testifier, the head of the Cornell burn unit, who came in and said, it's going to get 2 to 3 times worse in the future. She didn't lose her face. None of the others lost their face. None of the others lost their identity. This case is unique. Just as you said, Your Honor, I couldn't agree with you more. That's why this case stands on its own. There is no case like this. There is no case where a 16-year-old child lost his face, lost his identity. There is no case where that child had 120 surgeries, and we know that because of the contractures, his head is being pulled down. He's going to have spinal injuries. The city, they're very smart lawyers. They chose not to present any damages witness. None. None whatsoever. Judge Kern, in your case, in the Hackstraw case, you actually said specifically, and we taught with this as well, you actually said specifically that we should inquire, why is it that the juries in New York County are awarding numbers that are greater? Because they're based on reason. And here we're saying the city of New York hasn't shown you that this verdict materially deviates. It's not a runaway jury. It's not a runaway trial judge. Judge Tisch saw it. He felt it. He examined it. He carefully scrutinized it in his 38-page decision. That's why this case is such an outlier, just like the 91st Street crane collapse. It's an outlier. But no one, there is no case you can point to where a 16-year-old child lost his face having been an innocent victim when they didn't even bring in the most rudimentary, fundamental safety devices into that classroom. No fire blankets, no goggles, no showers. They couldn't even wash him off. The city says he was burning for a number of seconds. Not true. He burned for 57 minutes. I have the record, page 2579. It says it specifically. The methanol wasn't rinsed off. It continued to burn him until he was in the treatment room in the hospital because they didn't have showers in the classroom. And we learned at trial they didn't have showers in the school altogether. Yet the teacher brings in a gallon of fuel and pours it across an open flame, burning off this child's face.
And counsel, you're speaking of chemical showers, right?
Yes, exactly,
Not
Your
regular
Honor.
water showers.
They didn't even have water showers, Judge. They didn't have anything to rinse them off. Water would have been good. It could have at least taken some of the chemical off. They didn't have water showers. They had nothing there. They didn't even know of the existence of the science safety manual. That's why this was so wrong. But Judge Tisch carefully, excruciatingly in his 38-page decision showed why there are no comparable cases. And there are no comparable cases to what happened here. What happened to this 16-year-old child is something he's going to have to live with every day for the rest of his life. He doesn't have a vacation from this. He doesn't have a holiday. He can't get away from it. When you walk down the street with him, people go, "Oh my God, what happened to you?" He'll live with that for the rest of his life because of what happened. His face is gone. There isn't one other burn case where someone's face is gone, where their identity has been taken. This case is unlike any other case. That's why I say it truly is an outlier. It's a one-of-a-kind case. And for the city to come in here and say that the Pete case suggests that type of number, no. Christopher Pete was twice as old. The more recent cases, for example, Marion Hedges, argued by Matt Geyer, a wonderful lawyer, or Ben Morelli when he argued the Perez case, Mark Perez. We're not dealing with a 16-year-old. Each of them was 2 to 3 times older. Marion Hedges was 46 years old at the time. We're talking about a lifetime of pain and suffering every single day where he can't even walk outside. It's almost Halloween right now. And we know what happened when he went back to school. The kids taunted him and said, "Nice mask, Alonzo." The cruelty of kids, which you know about better than anyone. He wasn't even wearing a mask. This is what he has to go through. And now we know that adults who actually see him, they back away from him. Oh, what happened? Every day, this is what he's dealing with. This is so unfair for this child. This is a one-off case, a one-of-a-kind case. That's why what Judge Tisch did in carefully analyzing this speaks to the volumes of justice. I urge you, please take a look at the photographs. Take a look at what happened to this young child. I'm afraid to sit down because I'm fighting for the life of this young child.
Thank you, counsel.
Thank you, Your Honors.
I really would ask the court to take a copy of the Pete record and the Lee record, which I have both here, because they do show that the faces of both of those plaintiffs were severely burned. There are photos in the Pete record. His lips, his nose, his ears, his eyes, they were all burned. Lee as well. Lee lost his ears as well. There is no, and my colleague here focuses on things that happened at the liability stage. That is really not at issue here anymore. And the reason he's focusing on that is because there is no legitimate way to distinguish these cases. It cannot be claimed that Yanes' situation was as severe as Pete. After 2 weeks in the hospital, Yanes could walk. After 6 weeks, he could do yoga. After 10 weeks, Pete could not even
Counsel,
roll over
please,
in bed.
Please, please. Don't tell me he could do yoga. Please.
The record just
Please.
it's just to show what he could do. The point.
Spent 2 months in at the regular hospital to the point that the doctor there became his treating physician at Weill Cornell, and then he went to the Children's Hospital for 3 months.
Yes, Pete also was.
Counsel, we know this record, and you can't minimize it. You can't minimize
The
it.
fact that someone can do yoga when they have lost their face and they are severely deformed, it doesn't mean that, that the injury is any less because they can do yoga.
I apologize. It seems to have bothered you that I mentioned this. I did not.
No, it doesn't bother me. I just find it, to some extent, I find it insulting to say that the person can do yoga. That is minimizing the injury.
I'm not trying to minimize the injury. What I'm trying to show is that the injuries of the other plaintiffs in the other severe burn
Could they do yoga as
were
well?
also.
Are you going to tell me they could do yoga as well?
No, the point is that Pete couldn't even roll over in bed after 10 weeks in the hospital. His injuries were more severe. His pain and suffering was more.
Thank you, counsel. Your time is up. Thank you very much. Thank you both.